Hey everybody, News Now Wyoming. We're once again going to go over the case of Leon Valley. Just call this First Amendment Auditors versus Leon Valley. Last time we went over the initial complaint here. Number one, there was an amended copy, amended complaint right here, docket number 3. Uh, I'm not going to do a whole new video just on that. Didn't see a lot of differences, a little bit more clarification on some things, not important enough for the purposes of this series. If you guys want to, you can always come in here and read this yourself, do your own analysis. After that, I did read every single one of the documents that are attached to this that I possibly could get my hands on. So I've got a little bit more understanding of how the whole case here plays out. Although today we're only going to be going over one particular document, I'm going to be skipping some of this, and then one thing we're going to come back to. So a lot of boring summonses, yes, they all got the responses. There was a TRO, that's what we're going to come back and talk about at another time. I do want to go through the initial response of the defendants, and that's what we're going to be doing today. But there was a lot of stuff going on with a TRO for what was taken from the plaintiffs. So we are going to come down, and again, this is a lot. But before they answer, in August 31st, 2018, it looks like it was actually entered then as well. Number 29, so 28, 27 things since the original motion there. Okay, so we want to... Alright, so here, let's get that a little bit up there. So, once again, all the plaintiffs v. all the defendants. Civil action, if I want, blah, 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 boring stuff. Alright, defendant, Chief Salvaggio, Lieutenant Blah, their answer. Notice here, this is everybody but the city. Okay, that's important because there's another one that comes a little bit later here. Everybody here, I think, besides the city. And so most answers besides the city. Okay. Individually and in their official capacity, defends them the above entitled numbered cause and files this the original answer to the plaintiff's first amended complaint heretofore filed, and in support of would respectfully show unto the court the following. First defense. Plaintiff's first amended complaint fails to state a cause action against these defendants which upon relief may be granted. Okay. Now, you do see a lot of lawsuits being dropped due to this very first thing here. I do not know, and maybe I'll make an entire video after I research this a lot more to find out exactly what this means, what the standard is, and see if this is just baloney or if it can very well be dropped so easily. I am going to go through this just like I did with the plaintiffs. As I go through this document, I'm going to put it into the light most favorable to the person submitting the document. So in this case, I will be taking the cop's side. As I'm reading this, I'm going to treat it as if every bit of it is true, okay? That doesn't mean I believe it is true, but for the purposes of this video, I'm going to treat it like it's true. Second defense, defendants. Oh, this one says City of Leon. Oh, okay. That's his title. I see. Admits this action purports to arise from violations of their constitutional rights, 1983, as alleged in plaintiff's first amended complaint. However, defendants deny that any cause of action exists they're under. Deny statement of facts, paragraphs 32 through 37 of the amended complaint. You know what I kind of want to try to do is this. I think this might be easier. No, that is not what I wanted to do there. Alright, you guys, sorry as I'm going through this. Alright. So, paragraphs 32 through 37. Let's come down here to... this is statement of facts, the June 14th incident. So, everything about the June 14th incident. They are denying it in fact. So defendants would show into the court that plaintiff Mark Brown was arrested for interference with public duties under 3815A and resisting arrest under 3803. Said charges are currently pending with the Bexar County District Attorney's Office. Okay, so they are denying it because here... Are they denying that he was tased? No, they are not. They're just saying he was lawfully arrested. So they are not denying that he was tased. Okay. So was he tased? I've watched the video. I don't see him fighting back. Okay, again, since I'm going to go ahead, since they are not arguing the fact he was tased, they aren't denying it. He was violently arrested and he was maliciously and falsely charged. So they're going to deny that. They're saying that he was arrested according to the law. Okay. Fourth defense. Deny June 18th, 38 through 42. Oh, wait. This is the first amended. So, you know what? Give me 1 second here. Let's go back here. And let us just go ahead and open that up. That way we'll be better tied to where they're at. Okay, so 38 through 42, they are going to deny the June 18th incident. Because the detentions and arrests were made without lawful basis, and that excessive force was used. Defendants would show into the court that David Bailey was arrested for obstructing a passageway. James Springer was arrested for interference with police public duties. Said charges are currently pending. So who else was arrested? So they say that these two were arrested lawfully. Okay. So they say they protested with the thin blue line flag. They detained a lot of people. They're not denying this. Both policy in their supervisory capacities, unlawfully confiscated personal property from the people. They are not denying that. They are not denying that they unlawfully confiscated property against all the people present. Okay. Does this say who was arrested? No, this does not. Okay? But I do believe later on it does get to that. Okay. Alright. But they are not denying a lot of the stuff, just saying that they were lawfully, these two people were lawfully arrested. Okay. June 23rd incident, 43 through 47. Defendants would show into the court that Plaintiff Springer was arrested for retaliation. Plaintiff Howard was arrested for interference with public duties and resisting arrest. Pierce was arrested for interference with public duties and failure to identify. Defendants specifically deny allegations of unlawful seizure and excessive force as a matter of law. So nobody got excessive force used against them. And so here they say, so they don't deny that he held a fake press conference here. So that's got to be true, right? I mean, since they're not denying it. All those present, and he further ordered the confiscation. So they're basically going to say these people were detained. Yeah, they were detained for 5 freaking hours, but they were just detained. Okay, I'm not doing a really good job of this, of staying neutral here. But so I apologize to all the cop lovers out there. I have a hard time staying neutral. This is just complete crap. I mean, again, I just read this so-called press conference. I really want to know I really want to hear all that. Okay. 6 defense would show that the plaintiffs are a cabal of communication zealots intent on, blah, blah, blah. Okay, give me 1 second here. Let me do a search here. Definition, cabal. A secret political clique or faction. A cabal of dissidents. Okay, does it have a legal definition? Legal. The contrived schemes of a group of persons secretly united in a plot as to overturn a government. Also, a group engaged in such schemes is the legal one of the legal definitions here. Black's Law Dictionary actually says a small association for the purpose of intrigue. And intrigue, this name was given to the ministry in the reign of Charles II, formed by Clifford, Ashley, Buckingham, Arlington, and Lauderdale, who concerted a scheme for the restoration of property. The initials of these 5 names form the word cabal, hence the appellation. Okay. Related legal terms according to Black's Law Dictionary. Secure transaction. What? Okay, well, this definition, according to Black's Law Dictionary, that makes absolutely no sense. But contrived schemes of a group of persons secretly united in a plot as to overturn a government. So, okay. Light most favorable to the defendant, since they are the ones putting this in. They are a group that, with the scheme, that is secretly united to demonstrate police overreach and overreaction. Okay? Intent on bringing chaos and disruption. Okay, that's exactly what I just said, right? Showing police corruption to municipal governments, and in particular, the city of Leon Valley. Plaintiffs and their cohorts, through live feeds on social media instigation, conducted mass phone callings to city offices and mass email communications to city of Leon Valley offices, disrupting the government of the city of Leon Valley. How dare you pesky citizens, okay, listen to this, how dare you pesky citizens call us to redress your complaints. You have no right to do so. It's not like that is a that is not a definition to redress of grievances, the right to make a complaint or seek the assistance of one's government without fear of punishment, blah blah blah, Bill of Rights, petition of right. And this is something that goes right back all the way to the beginning. So wanting to call the government and complain about something that they are doing, that the government is doing, that the police are doing, shouldn't disrupt the government. Conducted mass phone callings to mass email communications. It takes so long to read an email. Contrary to their alleged self-imposed title of First Amendment auditors, plaintiffs are churlish fomenters. Okay, so churlish definition is rude in a mean-spirited and surly way. I'm going to assume that the other side had a bunch of typos, so I'm going to guess. Foment, instigate or stir up an undesirable and violent sentiment or course of action. Okay. Defendants insert into the court that plaintiffs' rights under the First and Fourth Amendments were not violated and plaintiffs were not subjected to excessive force as a matter of law. So, as a matter of law, their rights were not violated. Okay, again, light most favorable. Okay, stop it. News Now Wyoming, you need to stop looking at this and getting upset about this. Let's take that off, okay? Mr. Zinter, I'm going to leave it on you because I won't get mad at you because you were not there on the day of this press conference. Okay. Hold on. Oh, so that's still part of the sixth defense. Okay. Meet the defense plaintiffs Russell Zinter, 48 through 52. Defendants deny that Russell Zinter's constitutional rights were violated. So this entire thing here, they don't allege that they arrested him. They didn't arrest him up here, but they seized his property, and it was still in police custody. Okay. Okay, so they're just going to deny that his constitutional rights were violated, okay? Seventh defense, meet Jack Miller. Okay, he was open and carrying a rifle. So basically, this is Jack is saying he saw them getting arrested, so he didn't want to come back across the street. He was afraid to execute his First Amendment rights. So they're just going to say they deny that his First Amendment rights were violated as alleged in his complaint. Okay. Eighth defense, Brian Howd, 57 through 60. So charges against him were filed, dropped, and then filed again later. Okay. Deny that his allegations that he was arrested without probable cause. He was arrested and charged for interference with public duties and resisting arrest. So, interference with public duties. I really want to spend the time actually researching the law here and doing a video on these actual crimes and possibly looking at case law on these crimes that they are being charged with. His camera was taken, blah, 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 for allegedly and resisting officers. Is that what it means? No, that's that. I don't understand. Okay, yeah, I've really got to learn what charge for interference with public duties. I want to look at that case law, of settled case law, for that. James Meads. Unlawful detention, so that's not arrest, and unlawful seizing of property. They're going to just deny that his property and stuff were taken without permission. But this was also the one. He was given a trespass warning. He was not charged. He was staying on the street, so he wouldn't be trespassed. He placed him in the squad car. He searched his car, or him and his... Wow, okay. Under what... Okay. Again, light most favorable to the defense today. Light most favorable to the defense. I really should have made a sticky that says that, because this is harder than I thought it would be. Meet Brandon, or Joseph Brandon Pierce. Okay, and so this one, what was he again? His phone was being in police custody. They have denied to acknowledge that his phone is in their custody. He had a camera out and was live streaming the event. They groped him. Interference he was charged with, but the magistrate dismissed that charge. He was in custody for around 16 hours, including about 4 hours after the magistrate dismissed the criminal charge. Gave him... okay. So they are saying... what? Would show that he was arrested for interference with public duties and failure to identify. They're just going again deny that the constitutional rights were violated as a matter of law. Okay. Defendants would show into the court that plaintiff Mark Brown was arrested for interference with public duties and resisting arrest. They deny his claims of excessive force as a matter of law. At least 2 officers viciously attacked him, tasing him repeatedly, breaking some of his ribs. They seized his car under what? Okay. They're just going to say, you know what we did was fully legal, completely right, go the hell away. Okay. David Bailey arrested for obstructing a passageway in the foyer leading to the municipal court. They are going to just deny that his constitutional rights were violated as alleged. Again, you guys, I want to go through these complaints and actually look up the actual specific laws and what they say and what a reasonable person should take it to mean. I'm going to stop coming over here, though, because I'm getting closer to the stuff I don't want to see, because then I'll get really upset here. Defendants deny unlawful detention of plaintiff Juan Gonzalez Jr. as alleged in plaintiff's complaint as a matter of law. Paragraphs 119 through 128. Defendants deny plaintiff Kevin Egan's allegations of unlawful detention and deny his constitutional rights. Are we seeing a pattern yet? They're saying everything that they did was legal and it did not violate their rights, okay? Anything different here, they're going to deny that plaintiff Jonathan Green was unlawfully detained as alleged in plaintiff's complaint. Defendants deny that plaintiff's rights were violated. Defendants would show into the court that plaintiff James Springer was arrested for retaliation, again, because somebody posted on his live stream at some point in the past the chief's address. The defendants deny plaintiff's allegations of excessive force and deny that plaintiff's constitutional rights were violated as a matter of law. The defendants deny that plaintiff's rights under the First and Fourth Amendments were alleged. Plaintiff's complaint, plaintiff Mark Brown was lawfully arrested for interference with public duties and resisting arrest. Charges against plaintiff Brown are pending in the DA's office. Defendants assert that since charges are pending against plaintiff Brown, his civil suit be stayed pending the disposition of the state criminal proceeding. So he is the only one here that they've actually used this language. So everybody else is not pending. They were just charged with it. They are actually specifically saying pending. Okay? I think that's important. So that means everybody else, they know that they have no case. Defendants deny plaintiffs were unlawfully arrested and detained. Defendants would show to the court plaintiff Bailey was arrested for obstructing the passageway and plaintiff Springer was arrested for retaliation. Isn't that what you guys already said? Said are currently pending with the okay. Again, attorneys. Defendants assert that since charges are pending, so here they do say that again, so maybe down here is where they're going to start talking about Bailey and Springer's charges. Okay. Is this going to be the same type of crap? No. Okay, they affirmatively assert that at all times made the basis of plaintiff's complaint that they were acting in the course and scope of their employment as City of the Leon Valley police officers and peace officers of the state of Texas, acting pursuant to their discretionary capacity, and at all times acted in good faith, and therefore they are entitled to the protective shroud of qualified immunity and official immunity as a matter of law. Defendants affirmatively plead the protective shroud of qualified immunity under both prongs of the qualified immunity analysis. Defendants assert that their conduct did not violate a constitutional right and further assert that their conduct was objectively reasonable in light of clearly established law. Hogan v. Cunningham. So qualified immunity, you guys, of course, this is going to be the biggest hurdle to overcome for them. Did they, in fact, violate their rights? And do these guys talk about it enough in this document, well enough in this document, to overcome it? And is there case law to show that the officer should have known that this was good or that this was bad? Should they have known? Would a so the case law again, you guys, there's a lot of stuff to look into here. Okay, but these guys have to overcome qualified immunity for this to continue, because this hasn't even been argued yet. This was filed 2018, July of 2018. And this hasn't even been argued yet. Okay. Defendants would show into the court Plaintiff Pierce was arrested for interference with public duties and failure to identify. Bailey was arrested for obstructing a passageway, and Springer... What the hell are you guys doing? Okay, so the same things, they're just going to deny that the detentions and arrests were a violation of their First Amendment rights. Excessive force and violation, as alleged, they're going to deny it. That only a necessary amount of reasonable force. Is this 187? So here they're just going to say Meade was not manhandled, Gonzalez was not mishandled. Okay. Okay, that's fair that you guys can say that. I would disagree by the video, but okay. They're going to deny the 196 through 20. Man, I really don't want to be scrolling through this. Defendants deny that plaintiff's property was unlawfully seized. They assert unto the court that they have current criminal charges pending against them. Defendants assert that since charges are pending against these plaintiffs, this suit be stayed. So they do keep saying that now. Okay. Would show Springer currently has criminal charges pending against him for retaliation and interference. They assert that the pending criminal charges should stay plaintiff's Section 1983 cause of action. Blah blah. More of the same crap. Anything new here? Some more. They've been charged. They deny that he was falsely arrested. He was arrested for interference with public duties. Said charges are currently pending, okay? Again, more denials. Defense is certain to the court that all the officers are trained in accordance with the Texas Commission of Law Enforcement, and all officers maintain in-service training in accordance with state standards. Plaintiffs have failed to state a cause of action under Monell as a matter of law. So, when I research this cause of action, I'm probably going to start with Monell as a place to start and then go from there. Keep going backwards in time, coming forward, figure out exactly what the heck that means. They were acting in the course and scope of their employment. They are entitled to qualified immunity. They plead both prongs that the conduct did not violate a constitutional right, and then, even if it did violate a constitutional right, it is objectively reasonable in light of clearly established law. Okay? Further assert their defenses under this. Who the hell cares? Okay, that's a boring paragraph there. You guys are boring me now. They're entitled to compensatory and punitive damage. Deny that plaintiffs are entitled to anything because they are complete crap. They are a cabal. They are terrorists. And they are trying to bring down our government. Shame. Shame on you guys. Hold on, let's go to their names here. Shame. All of you. Shame, shame. You should just go home and cry yourselves to sleep. You are so shameful. They're also demanding a jury trial. Well, good, because guess what these guys also did? They pray plaintiffs be dismissed against them, or on the alternative, that the plaintiffs take nothing by their lawsuit against them. The defendants have judgment herein, that the defendants be awarded their costs expended, including reasonable attorney fees, and for such other and further relief, both general and special, and at law and in equity, to which they may show themselves justly entitled. Alright, so you guys, I'm about to end this here, but I do want to know, what do you think of the cop's suit here? I'm going to be doing a couple things now. After reading the entire case file so far, I'm going to put out there, each one of these should have filed separately. I'm going to be telling you guys why during later videos. I think each one of these should have filed separately and on their own. They would have been a lot better off for their case if they filed each one individually. I can see if one, two, or three of these are deemed bad. Later in the case file, you'll be seeing that the court continues to say the plaintiffs all treat this as one action and not individually. And so we, the court, also do not. So we as a court are going to allow horrible, horrible things to happen to this case because one person is still charged, or one person did this, or one person did that. Okay, so that is my own personal opinion. I understand that there's legal strategy behind this. I think in this case, each one of these would be better off to put in a motion to splinter off into their own lawsuit. Maybe still represented by the same guy. Okay, I don't want to deny that to Mr. Radner. And I do want to look him up a little bit more and do some more research on him. But I do think that they should have filed separately. Okay, another opinion here. This case is going to get dismissed by the district court. Yep, I believe that. I believe that upon reading further into this case, reading further arguments later on, looking at different case law on some of the merits here. I think unless, as soon as the motion is brought, we've got to see exactly what this attorney, Mr. Radner, brings to the table, what he's got up his sleeve so far. He's not doing a great job in other documents, so I hate to say it, I think in the district court they're going to lose. In the appeals court, okay, so the district court is going to deny all, because they are treating them as all as one. Okay, I think the appeals court is going to turn around and reverse in part and sustain it in part. I do. I think some of these guys in here don't have as strong of a case as others. I think others in here, there are good guys and there are bad guys. Not really as a whole, you guys. I'm not talking bad about anybody here, but legally speaking, as far as having a case, I think the district court is going to deny it in whole. Then the district court is going to come along and say, "Oh, this guy's was definitely violated," or "That guy's I'm not doing that to any particular person on purpose." Okay, there's no rhyme or reason to where my mouse is at here, but as a whole here, they're going to get denied in district court and partially reversed in the appeals court. And we'll be going over that more. Also, I beg everybody here, let's just do one quick refresh. I did this earlier. Okay. January 31st, there was a hearing. No order has been put in here. Does anybody have a copy of the minutes that you can send me? I would appreciate, greatly appreciate the minutes here. I would kind of curious to know how this went. I'm not in Texas, I'm in Wyoming, and so it's a lot more difficult for me to get stuff from the court itself. Also, there is audio of the hearing. I don't know where it's at, you guys, I'm sorry. With the chief of police, where he claims to have all kinds of stuff against the FBI and stuff. I've heard the 5-minute spiel. I remember the 5-minute spiel when it was posted last year. I've never heard the full audio. Can anybody send me the full audio for that court hearing? I would love to hear the chief of police speak. I really want to get to know what he's saying. It's alluded to in these documents, and it's alluded to on other videos on YouTube. There is a 5-minute blurb out there, but I would really like to hear the whole thing. So if anybody knows how or who would have a copy of the full thing, I would appreciate that. If anybody knows who's got a copy of the minutes here, I would appreciate that. We are just waiting for the final order to come out. It has been almost 2 full weeks. I do know that Monday is a federal holiday, so if it doesn't come out tomorrow, expect it midweek next week, or even later. I mean, these things can take months for the judge to say, to pull their heads out of their ass. What this actually is the stay. There is a current stay, and there has been for a long time. So, of course, the plaintiffs want it to go on or to stop, and the defendants say, no, let us keep the stay. Again, we'll be getting to those documents later. They are way down there. We've got a lot of catch-up to do here. So, okay, you guys, let me know what you think. Put in the comments below. And do a little bit of research with me. Look up stuff. What is it you want to see here? What law do you want me to look at? What particular things about this case do you want to see? Or should I just go through it like I am and just half-ass pull this document or that document. No, these were boring, so we're not going to do these. We will be, of course, doing the motions for the TRO. I want to go over the TROs in full, and then what happens with that TRO and what that TRO is even for. So those will be done in later episodes, and I'm really looking forward to doing that with you. So be sure to stick around. Thanks. Bye.